Mr. Duffany, please introduce yourself to the court.
Right from the opening seconds, this courtroom sets a tone that's deceptively routine, but underneath, there's instability brewing. A probable cause conference might sound procedural, almost administrative, but it's actually a critical checkpoint where the direction of a case begins to take shape. And here's the first red flag. Defense counsel was just appointed yesterday. That immediately signals lack of preparation time, limited access to discovery, and a potential disadvantage for the defendant. When attorneys request adjournments this early, it's not strategy, it's necessity. But judges don't always grant that flexibility easily, especially when there are compliance issues already in play. Now layer on what's about to unfold, a bond violation tied to testing compliance. This is where cases begin to spiral. Our courts treat bond conditions seriously because they reflect whether a defendant can be trusted outside custody. The moment compliance is questioned, the entire posture of the case shifts, from neutral to skeptical. And notice how quickly the conversation pivots toward drug testing. That's not just a side issue, that's leverage. This opening is quiet, but it's loaded. You're watching the foundation of credibility being tested before the case even gets moving. The real question is, once doubt enters the courtroom, can it ever fully leave?
Thank you, Judge. Today's the date and time set for probable cause conference. I was just appointed on this matter yesterday afternoon, so we are asking for a brief adjournment for discovery and for plea negotiations. At this time, there's also a bond violation, or
there is.
Yes, Judge. So I spoke to Mr. Duffany. He went to community corrections yesterday at 4:20 p.m., but he did not have the money to test, so he was unable to. We did discuss today. He's going to go immediately to community corrections after this. I do have an email from community corrections to confirm that he was there.
Is he going to test clean?
I believe so, Judge. Yes. He's on what?
Are you going to test clean?
I'm on Suboxone. I'm prescribed Suboxone.
You're prescribed it? I'll pass it. He needs to get over there and test and then come back.
So thank you, Judge.
I'm not doing that anymore. Takes a lot. Just go on. Court recalls the case, People versus Justin Duffany. Yeah.
Good afternoon again, Your Honor. Good morning, Chief Assistant Prosecutor appearing on behalf of the people.
Can I put it back on the record with Mr. Duffany? Justin, please state your name for the record.
Justin Duffany.
I've seen the results, Judge, and I have gone over them with Mr. Duffany.
He doesn't have a prescription for cocaine, Mr. Allen.
I would assume no. Gonna be all right. It'll be all right.
All right. I'm going to adjourn the probable cause conference to August 14th, 2025, 9 a.m. His bond at this time, given the violation, his bond is revoked. Defendant's remand.
Thank you, Judge.
And there it is, the turning point. Bond revoked. This is one of the most consequential decisions a judge can make at this stage. It's not about guilt or innocence. It's about trust. And in this moment, the court is saying clearly that trust has been broken. When bond is revoked, the defendant goes from conditional freedom to immediate custody. That shift changes everything. Legal strategy, negotiation leverage, even psychological pressure. A defendant in custody is far more likely to accept plea deals simply to regain freedom sooner. Notice how quickly this decision is delivered. There's no long deliberation, no extended debate. That tells you the violation, combined with the uncertainty earlier, was enough to convince the judge that compliance is unreliable. Courts prioritize control and predictability. If those are gone, that custody becomes the default. This is where cases start to snowball. One missed condition leads to stricter oversight, which leads to fewer options, which leads to higher pressure. The bigger question here is, was this a one-time slip, or does the court now see a pattern forming? Because if it's the latter, every future decision in this case just got a lot harsher.
Good morning, Your Honor. Assistant Public Defender Constable Bass on behalf of Mr. Brandon Bowman, who's present to my right. Can you state your full name for the record, please?
Brandon Charles Bowman.
Today's date and time set for a probable cause conference. At this time, respectfully requesting you set this for an exam.
If I can address bond, Your Honor.
Are you going to address the additional bond violation report that we have? There's something else?
Yes.
Oh, lovely. All right. You want it set for exam
Yes, Your Honor.
and you have the discovery.
To my knowledge, yes.
Would people have their witnesses available at 12?
We'll do our best, Your Honor.
Preliminary examination in person will be set August 12th, 2025, 9 a.m. before Judge Fresh Hour. As to bond.
Your Honor, I believe the defendant is in custody on a no contact order bond violation originally. After he was put back into custody, he's tried to contact the victim 21 times. None of the calls have been successful, but he has tried to call her listed number in the police report.
Now the stakes escalate dramatically. 21 attempted contacts with a victim under a no contact order is not a minor issue. It's a direct violation of court authority. And even though none of the calls were successful, the intent alone is enough to trigger serious consequences. No contact orders are absolute. They don't operate on intention or outcome. They operate on action. Attempting contact is treated the same as making contact because the court's priority is protection and control. What makes this moment even more tense is the defendant's denial. This creates a classic courtroom conflict. Documented evidence versus personal claim. And judges are trained to rely on records, logs, and verifiable data, not statements made under pressure. The defense tries to pivot, questioning whether the calls were actually tied to the defendant's PIN. That's a smart move. It introduces doubt about authorship, which is critical. But notice how the judge responds, not dismissing the claim, but also not accepting it outright. Instead, the court pauses and investigates. This is a high-stakes credibility battle. If those calls are proven to be his, it reinforces a pattern of non-compliance. If not, it exposes a flaw in the system. So here's the question. Do you think this is a misunderstanding? Or someone trying to bend the rules without getting caught?
Since being put back in for violating the...
And at this time, what's his bond? Is it revoked?
I have it as denied, Your Honor.
Yeah, that's what it should be. All right. As to that,
Your
Mr.
Honor, I haven't seen anything about these calls. My client is saying that he's...
I have not made one phone call.
Your Honor, he's going to be asking for a PR bond. He's been in for 8 days.
Is the phone calls that he made, is that attached to his pen?
Your Honor, I'm trying to pull up my internet and not.
Okay. I understand you're saying that none of the calls were completed, but were they made from his pen? That's what I'm trying to figure out. Well, why don't we do it this way? Mr. Ovesi, you can talk to the prosecutor's office regarding that. If they did come from, I'm going to, at this time, I'll revoke his phone privileges. I will reinstate them if they did not come from his pen. Okay. So get with the prosecutor's office and I should have that answer as soon as their internet goes back up. All right, sir. All right. Otherwise, bond will continue as denied.
Your Honor, we have it pulled up real quick.
Oh, you do have it? Hold on.
They're from different pins.
They're from, are any of them his?
No, they're all different pins. There are 2 different pins that are being used, but not this.
And none of the calls were connected?
Correct.
All right.
This moment flips the narrative, at least temporarily. The evidence shows the calls came from different PINs, not directly tied to the defendant. That weakens the prosecution's position and gives the defense something they desperately need, plausible deniability. But notice how the judge handles it. The court doesn't immediately restore full trust. Instead, it cautiously adjusts, denying the revocation of phone privileges but keeping the broader bond concerns intact. This is judicial balance in action. The judge is saying, I'm not convinced enough to punish you further on this point, but I'm also not convinced enough to fully trust you. This is how courtroom decisions often work, not black and white, but layered. Each ruling adds or subtracts from the defendant's overall credibility score. The defense then pushes for a PR bond, arguing time served and willingness to admit the violation. That's a strategic move, accepting responsibility to gain leniency, but the judge shuts it down quickly. Why? Because admitting a violation doesn't erase the risk, it confirms it. At this stage, the court isn't looking for admissions, it's looking for reliability, and right now, that's still in question.
I'm going to deny the request then to have his phone privileges revoked at this time.
Your Honor, my client is asking for a PR bond. He's been in for 8 days.
I have a conditional bond violation. That's why he's in.
I understand. He's willing to admit to the bond violation and ask for the 8 days without a hearing. If
I would not be sentencing him to the 8 days on it.
Understood.
I can tell you that. So does he still wish to admit to the violation? Yeah. Well, that's okay. Yes, I'm going to need one for you.
Okay. Understood, Your Honor. Then we'll keep it as it is.
Sorry. Once I check your pending screen. Yeah, man, I'm just a figurehead.
Alexander, on behalf of the people, Your Honor.
Covered on behalf of Mr. Amison, who's approaching the podium. Amison, please state your name for the record.
Mario.
So, Your Honor, there's a date and time set for probable cause conference. I was recently appointed. However, we are asking, I do not believe that there is video in this case, so we are asking that the matter be set for preliminary exam.
And if I could address for free, Your Honor.
Why am I not shocked? Okay. So you believe you have all the discovery?
I believe so, Judge.
Would the people have their witnesses available to 12?
We'll do our best, Your Honor.
Preliminary examination, August 12th, 2025, 9 a.m. That is before Judge Freshour. Yes, that's the bond.
Your Honor, it's come to my attention that Mr. Amison has called the victim in this case 100 times since his arraignment. So at this point, I would be asking.
What? 100 times?
100 times.
Okay.
This is escalation on another level. Not 21 attempts, 100. That number alone changes the entire perception of the case. It suggests persistence, disregard for court orders, and potential pressure on the victim. The defense tries to explain confusion about the no-contact order, the victim initiating visits, mixed signals. And to be fair, that confusion does happen. Defendants often misunderstand that no contact means absolute, regardless of who initiates. But here's the reality. Misunderstanding doesn't excuse violation. The defendant's own words add complexity. He argues that if the victim could visit him, the order must not be serious. That's flawed logic, but it's also human logic. It shows how easily legal rules can be misinterpreted outside a courtroom mindset. The judge, however, stays focused. The key issue isn't who started contact. It's whether the defendant responded or initiated prohibited communication. This moment is critical because it shows a clash between legal reality and personal perception. And in court, legal reality always wins. So consider this. If someone genuinely doesn't understand the rules but still breaks them, should the consequences be the same as someone who knowingly violates them?
So I would be asking that his phone privileges be revoked. It's her listed number in the school report as well.
Response?
So, Your Honor, I spoke with Mr. Amison in the jail recently. We went over the no contact.
That wasn't on the phone, was it?
No, Judge.
My bad. Go ahead.
Technically, it was, Judge, because it was through the glass. So we did have a discussion on it. I explained that the no contact order, even if he receives contact from the complaining witness, he's not allowed to respond, or to, I don't know, I got it. Or if he is, even if she wants contact, it's my understanding that she does want the no contact order lifted, but we did explain what it means to have a no contact order in place. And with going forward, I'm confident he will not be making any more contact and reaching out to the victim at all.
Excuse me, just not talking.
What do you want to say?
She came and visited me, man. They let her come visit me, so it couldn't have been that serious of a non-contact.
So, we did discuss what the no contact order means. And so at this point, we are asking we're already set for preliminary exam. So, and in the
domestic violence or nothing, man. It's a fraud case.
We got it. It's my understanding that the complaining witness has reached out to him several times, so that he didn't really understand what the no contact order meant. We've explained it. We've hammered down that no contact means no contact. So that at this point
Let me ask this then. Other than those times where the defendant's alleging that the victim has come toward him, are the phone calls his calls out to her?
Your Honor,
Some are from his pin and some are from other pins.
Well, I understand that, Mr. Burdell, there might be a mix-up when she comes there. And
I got one more thing to say, man. You ain't wearing it right, man. Excuse me, can I talk? I know how to talk. You feel me? I got you. She came.
Sure, go ahead.
She came to the jail to visit me.
I heard you.
I haven't seen nothing, and mail said no contact. How is she able to visit me if it's a no contact order and I'm in jail?
That I don't know, and that's why I asked if there were. I'm trying not to take those contacts where she's making them with you into consideration, because your attorney just explained that you had a conversation about how you have to respond to that. Then I asked, were there phone calls from or contact from you to her, which would be strictly prohibited?
Right. Well, I was under the impression that I wasn't able to have no contact upon my release. They said during bond, we can't be in the same household. They never said about calling her from jail. This is not no domestic violence issue. This is a fraud for $30. That she clearly called the prosecutor and said she didn't want to press charges.
I don't know any of that, sir. I don't.
Because they telling you half the story, man.
I'm not going to get that information right now. I'm not supposed to have that information right now. Anything else, Mr. Anything else, Mr. Burdell?
no, Judge, not at this time. Thank you.
At this time, and this is only for the calls that he's making out, either from his own pen or from other pens, because that is not allowed and strictly prohibited. The defendant's phone privileges at this time are revoked. You can make the argument before Judge Freshour to reinstate them after the preliminary examination.
Thank you.
Thank you.
You five, man.
What'd you say?
You five.
Come talk to you, Mario.
You just want me to go? You don't want me to go? You want me to stop on that and say something? You just want me to keep going? Really? Okay. All right. I'm gonna pick up the next one and just. This is on your advice, because I got something to say, but I'm not going to. Court calls the case, people.
The final ruling lands with precision. Phone privileges revoked. This is a targeted consequence, not full bond reconsideration, but a direct response to the behavior in question. The court is tightening control exactly where the violations occurred. This decision sends a clear message. The judge is not escalating to maximum punishment, but is systematically removing opportunities for further violations. It's controlled discipline, not emotional reaction. Throughout this entire sequence, the pattern is clear. Repeated boundary testing, partial explanations, and incremental loss of privileges. Each moment chipped away at the defendant's standing in the eyes of the court. From bond revocation to communication restrictions, the court has shifted from giving chances to enforcing limits. And that's the broader lesson here. Courtroom patience is not unlimited. It's conditional. In the end, this case isn't just about the charges, it's about behavior under supervision. And in many ways, that matters just as much. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.